Right, I hereby call this meeting back into order. This is the City of West Palm Beach Code Enforcement. If you weren't here earlier and you haven't been sworn in, would you please rise and raise your right hand if you're going to testify or there's a possibility that you're going to testify? Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida? All right, please be seated. City can call the first case.
Other matter number 6, CE 19020390, 517 Clematis Street, Hullabaloo is the business.
If you hear your case heard, go ahead and proceed to the podium on my right-hand side. The city will present its testimony and evidence first. You'll be given an opportunity to respond to that testimony and evidence and present any testimony or evidence that you have, after which I will make a decision. Thank you.
Agent Colvin, City of West Palm Beach Police Department. Do we want to? We spoke about stipulating. Do you want to do the stipulation or go through with the full testimony?
I think if we could just do the stipulation, I think that'd be fine.
We spoke with them beforehand. They're stipulating that the violation did take place, and the city is asking for a $250 one-time fine, and then for them to do training within 6 months. For point-of-sale vendors and just provide proof of that training. They could do it through the company you're currently using, or we can provide one for you guys if you need one.
Sir, can you tell me your name, please?
Frederick Castle.
Frederick Casson?
Castle, sorry.
Castle. So do you understand that you were stipulating that to a violation of 612 and that you're going to pay a fine of $250 and obtain training for vendors within 6 months?
Yes, sir.
Okay. In case CE 19020390, I make the following findings of fact and law. If I notice is sufficient, I find a violation of 612. I order a fine of $250 and the respondent to complete training within 6 months.
Mr. Wagner, can we have Mr. Castle put on the record what his attachment is?
Yeah, okay. That's a fair point. Should have done that. Can you tell me your connection with the respondent, Hullabaloo?
I'm the executive chef and manager.
Okay. As far as the stipulation is $250 and training within 6 months. Thank you,
Yes,
sir.
sir. Thank you.
Other matter number 4, CE 19020385, 306 Clematis Street. It's Clematis Street News.
Agent Colvin, City of West Palm Beach Police Department. On Friday, January 25th, 2019, I was working part of an undercover operation designed to check point-of-sale vendors, confirm that they're properly checking ID prior to selling alcohol. At approximately 22:30 hours, I sent a confidential source into the Clematis Street News and Wine at 306 Clematis Street. The sources walked to the freezer area, retrieved 2 Corona extra light beers. The female clerk, there was a picture obtained of them, sold the beer without asking for the confidential source's age or identification. It should be noted the confidential sources were 19 at the time of the buy. The entire incident was observed by me standing outside the store. This is their first offense. We believe that they violated, the business has violated City Ordinance 6-12. We are asking for a $250 fine and training to be completed within 6 months.
Sir, can you tell me your name, please?
First name is Peter, last name Soreco.
And what is your relation to the business Clematis Street News?
I'm the director of 2 operations, the Clematis Street News Liquor Store, which is the market on Clematis, and the Clematis Street Newsstand.
So you're responsible for the operation of this
Yes.
restaurant? Okay. So is there anything you'd like to tell me about this? The city is saying that you violated 612 by selling alcoholic beverages to somebody who was under the age of 21 without asking for identification. They're asking for a fine of $250 and for that, for you guys to complete training within 6 months.
I totally agree, and the only thing I have to say is that the party involved was a brand-new employee who it's my responsibility to train them better.
Okay. Are you in agreement with that?
Yes.
Okay.
May
Yep.
I ask,
Go ahead.
Sir, do you have the authority to represent and bind the owner?
Yes.
You're responding to the affirmative to the question that you have the authority to represent the owner?
Yes.
Yes. Okay. Is that satisfactory to the city?
Yes.
Okay. In case CE 190203885, I make the following findings of fact and law. If I notice is sufficient, I find the respondent was in violation of 612. The respondent shall pay a fine of $250 and complete required training within 6 months.
This-
If you'd like an order
Right there.
for today's hearing. Other matter number 5, CE 19020389519 519 Clematis Street, Kapow Noodle Bar. That's yours.
I'll have it just in case.
Do we have a respondent for this case? No. Nobody signed in. Go ahead, Officer Coleman.
All right, Agent Colvin, City of West Palm Beach Police. On January 25th, 2019, I was working part of undercover operation designed to check point-of-sale vendors that they're properly checking ID prior to selling alcohol. At approximately 22:05 hours, I sent 2 confidential sources, both at the age of 19 at the time of the buy, into Kapow Noodle Bar at 519 Clematis Street. Upon entering the store, they made contact with a white male bartender, pictured there just briefly ago. Ordered a Mama's Little Yellow Pills, which got 5.3 alcohol by volume. They were served the beer without being asked for ID or asked their age. I believe that the business itself violated City Order 6-12. This is, it may say on the agenda, the second offense is actually their 4th offense. And the city's asking for a $2,000 fine and training to be conducted within 6 months.
Have you had any contact with the owner of the?
I personally have not. They were posted, and then I had an officer go by and advise the manager on duty that they had failed.
You clearly must have those pictures taken before you tell them that they sold liquor.
Yes. We don't, for the downtown operations, we don't tell them until the operation is completely done, because if I do tell one place, every single place downtown will know that we're doing those operations, so it wouldn't be fair to the first place that violated towards the last one, because they would all know by the end.
For the record, is there anyone here on behalf of the respondent, Kapow Noodle Bar? All right, in case CE 190203889, to make the following findings of fact and law, I find notice is sufficient for the property in violation of 612. I hereby order a fine in the amount of $2,000, and I order the respondent to conduct appropriate training and submit proof of that training to the city within 6 months.
Other matter number 3, CE 18050663 3314 Poinsettia Avenue.
You did say poinsettia, right?
Yes.
Go
Ms.
ahead, sir.
Posner, Code Enforcement, case ending in 663, 3314 Poinsettia. Date ordered 8/15 of 18, fine started 8/23 of 18, ran for 55 days. Current total $2,750, $50 a day. Date of compliance 10/17 of 18. It is under new ownership, but this is actually the previous owner applying for the application. There's no mitigating factors, just saying they didn't receive it, but it was sent to the proper address. City's asking for 50%.
Ma'am, can you tell me your name, please?
Good morning, Florence Turgi.
So tell me what you're asking for and why I should give it to you.
In fact, we never received the violation notice. The tenant never let us know. I am the property manager. And in fact, all the correspondence went to the previous property management company, and they never forward the mailing.
You have to speak a little slower for me, ma'am.
Sorry. In fact, I never received any notice, any correspondence, and only the tenant who didn't inform us. And all the correspondence from the city was sent to the previous management company, so I was not aware of it. In fact, I realized there was something wrong when we put the property on the market for sale, and we went into a contract, and we were aware there was a lien. In fact, there was 3 liens. And so we contact right away the tenant, we take action as soon as we were aware and take care of the property. So,
Hold on one second. So was the notice sent by certified mail to the,
The notice was sent certified and regular mail to the address listed with the county. I have no reason to doubt it was the previous property manager company, but they didn't change the address with the county.
yeah, it seems like the mistake was that you guys didn't update your records. The city's requirement, the obligation for the city is to send its certified mail to the address listed in the property appraiser's records. It's your responsibility to make sure that that address is up to date, because can you imagine if the city had to try and figure out whether people were updating their addresses or not?
I know, I requested it, I sent like mail to change the address, but not in certified mail, so I guess it doesn't count.
Well, the current fine is $2,750. I'm willing to reduce it to $1,375 or to cut it in half if it's payable within 30 days. Okay?
Okay, thank you.
Would you like a copy of your order?
Yes, but if I may ask, I was thinking I was coming for the 3 liens we had on the property, so I don't know.
Are you aware of any
I'm
other liens
sorry?
on this property?
There is 2 other liens on the property. When we,
Check computer real quick.
I had
The
those-
other 2 liens were paid.
Yes,
They paid them.
yeah, but the thing is like, when we sold the property, we asked the title company in order to close to put the 3 amount for the 3 different fines of the 3 different liens on escrow. And we request lien reduction to discuss with you, to be in front of you. And the city says it's going to take up to 60 days. So we asked the title company to hold on to the money, and she didn't. She went ahead without our consent and paid the 2 other liens in full.
I'm not sure if I can reduce a lien that's been paid.
I know, but if you...
I don't even know how I would do that.
Now, as far as the city is concerned, it's already been paid. Now that I'm hearing this, I remember the rest of the details on it. Whatever's going on between her and the title company, the money was sent to the city, the liens were closed due to the payment of the liens, and
I don't
they would
know.
have to address that
Let me-
with...
This is news to me. I've been doing this a long time. It's a relatively new circumstance to me. I've never had anyone come in after a lien's been paid and ask for a reduction. But let me put the city attorney on the spot here. Do I even have the authority to reduce a lien that's been paid?
But the reduction was requested before it was paid.
I do not believe that there would be any authority to do that, and at this point, it sounds like it would be a civil matter between the property owner or the prior property owner and the title company.
Yeah, I kind of concur with the city on this. I don't think I have the authority to reopen a closed lien.
But even if
I don't know what jurisdiction I'd have to do that. I can reduce extant liens, ones that are in existence according to the Chapter 162 and the City of West Palm Beach's code, but I don't know any either ordinance authority or statutory authority that would allow me to reduce a lien that's already been paid. I just don't have the authority to do that.
Can I just say something? Those 2 liens were from 2003 and 2009. It was for $2,900 and $1,100. My client was not even the owner. He bought the property in 2012 with a title insurance, meaning like the property was clear, free of title, like there was nothing on the property, no lien. So we came up with those liens at closing.
Ma'am, the best I can recommend for you is that you need to speak to a real estate attorney that can maybe give you some advice on that. If there's a rationale that they can come back to me or to whoever's the magistrate at any given time to do that, and there's a legal basis to do that, I'm sure the magistrate will hear it. But at this time, I don't know what I could do for you, even if I wanted to.
even if those lien was attached to a personal person, the previous owner, and they say they will go towards her if she buy a new piece of property, something else, you know?
Yeah, I can't give you any legal advice from the bench because it's wrong for me to do so, and I don't know enough of your situation to do so, but I'd recommend that you consult with legal counsel.
So you cannot review those two liens?
I don't know of any authority I would have to review a lien that's already been paid.
Ma'am, I'm happy to talk with you about some of your questions at the end of the hearing, if you'd like.
Yeah, because we called the city like at least like 50 times, and Monique, like so many different person, like willing to help, and after saying something else, and I was a little bit
I would
confused.
recommend.
We
yeah.
want to do like the things like to be like up to code and by the book, but I don't think it's
I
fair,
appreciate that,
you know?
but it's a weird.
Just-
I've been doing code matters for a long time, and I've never actually had the circumstance where someone's come back after a lien has been paid off. I mean, typically, what you often seen is that they will hold money in abeyance during the portion, and then they will,
That's
then
what we
decide how
asked
to
them
do
for.
that. But I've never seen them paid off and then come after and ask
I
to
know.
reduce it.
So at least can you, because we wrongfully pay those two in full and doesn't even belong to my client, can you cancel the third one in full? Like,
Yeah, I have to treat each one individually, ma'am.
so 50% is the best you can do.
I think 50% is reasonable since the city followed all of their procedures.
Okay, thank you.
If I can get your contact information after the hearing?
Yes, please. Thank you.
Other matter number 2, CE 17020462, 949 30th Street.
Are we one or two? Two. Do we have somebody here on this one?
Yes.
Yeah, come on up.
Good morning.
Good morning. I'm going to let the city give me some background, and then you can tell me what you're asking for and why I should give it to you.
Case ending in 462 949 30th Street. Date ordered 4/5 of 17. Fine started 7/5 of 17. Ran for 316 days. Current totals 31,600. Daily fine $100 a day. Date of compliance 5/17 of 18. It's a new owner, but other than that, there's no mitigating factors whatsoever. The city has some trouble with this particular property owner due to issues with other properties. We're asking for 30% of this. So normally it would be 50, but with a $31,000 lien, we'll be more reasonable and ask for 30.
Okay, ma'am, can you tell me your name?
Anita Green?
Have you guys been sworn in yet?
No.
No, okay. Please raise your right hand.
The new respondent.
Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury?
Yes.
The gentleman back there has not either.
Sir, are you here to testify on a case? Yes. Would you please stand and raise your right hand? You swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida? Yes. All right, please be seated. All right. Can you tell me your names, please?
Anita Green?
Mitch. Sharon Restrepo.
I'm sorry, one more time.
Anita Green?
Anita Green.
Sharon Restrepo.
And what is your relationship with the property owner, Gregory Blackshear?
He's no longer the owner.
Oh,
That's the
okay, so
prior
you're
owner.
Dolphin Real Estate Acquisitions and Management,
That's me, Anita Green, yes.
and that, you own that company?
I do.
Okay, and you, ma'am?
I just help her.
Okay. All right, so tell me what you're asking me for and why I should grant it to you.
I'm asking for a better than 30% reduction, maybe down to a smaller amount because the property was out of compliance when I bought it, which of course I knew. But the holdup for getting the property into compliance was just a misunderstanding of what I thought I could do with a building that was on the property. So the whole property is currently in compliance. Any property that I own is currently in compliance. And I just wanted to state that for the record. I have pictures. Here they are. So the property was basically lived in by someone who, over time, it just went down. You know, it wasn't like a nuisance house, so to speak, but the code enforcement had cited it, like Mr. Mitch said, in 2017 in February, which was before I bought the property. So I bought the property and began immediately getting it into compliance, which at the time was some landscaping issues, some rotten wood, and a shed. The shed ultimately had to be demolished. So the property is currently in compliance and is very nice.
Ma'am, did you know the property was under subject of a code enforcement proceeding when you bought it?
Yes, and I started right away to get that fixed. When it comes to the matter of the shed, I was under the hope that I could renovate the shed, but it took a long time for me to discover that it was not redeemable. And so eventually I had to demolish it.
It was like a one-car garage in the back, not so much a shed. And she was
Yeah.
going to
Make it
fix
into a
it up
she
and-
shed or a man cave, make it really nice and suitable for the property, but it couldn't be saved.
Well, it's quite a risk to purchase a property that's got a lien on it. You can't assume that the city's going to either waive their lien or a magistrate will. I mean, did you not take the risk when you bought the property?
She did, but she called the code officer and said, tell me what I need to do, and, what does it look like, and when I go to reduce this, and she was told, I can't make you any promises, of course, but it's typically 10%. And that's why she went ahead with it.
And it's a big improvement to the street. I mean, it's a beautiful property, where at first it was like they cited, horrible garage, terrible landscaping, and some rotten exterior.
And she spent a lot of money.
Sir?
You go ahead.
I really want to object to the characterization of a misunderstanding on the shed. The misunderstanding was told that this needed to be repaired, rotten wood, and they went ahead and demoed the shed without a permit on a historical property. That was the holdup on getting this to a hearing in the first place. As to it being 100% in compliance, now we have no disagreement, or it wouldn't be here for a hearing.
I did have to go before the historical board, and we had the hearing, and Frederica Mittner was able to give information to the board that the property itself wasn't, having to eliminate the garage did not adversely affect the neighborhood or the property.
All right, I'll tell you what I'm willing to do. The city wants 30, you want 10. I'll split the difference at 20%, which is $6,320 payable within 30 days.
Thank you.
320.
Thanks. And here's a copy of your order. Have a good day. Other matter number 1, CE 15120588, 847 Flamingo Drive.
Case ending in 588-847 Flamingo Drive. Date order 2/3 of 16. Fine started 3/7 of 16. Ran for 959 days. Total $95,900. Daily fine is $100. Date of compliance 10/22 of 18. It's the same owner. There's no mitigating factors other than didn't know. Blames the rental agent, which is the owner's responsibility. And didn't even apply for the license until a month after learning about the case. City's asking for 30%.
Sir, can you tell me your name? And tell me
My
what
name
you're
is
asking
John.
for and why I should grant it to you.
My name is John Lotito.
John Lativo?
Lotito.
Lotito. Okay. And you're Jean-Marie Lotito, is that you?
Jean Marie is my daughter.
Okay, so are you speaking on her behalf?
I am.
Okay. And she authorized you to do so?
Yes, she did.
So tell me what you're asking me for and why I should grant it to you.
Okay, I'm asking for the reduction in the lien due to the fact that when we bought this house, it was a short sale. My daughter was going to live in it, and she wound up with a job opportunity in California. We decided to keep the house. We renovated it because it was falling apart. At that point, she moved to California, and I hired the realtor who sold me the house to rent it out. And I expected her to know what the laws of Florida were, since I live in New York. And I found out about the lien accidentally when we came down here last August, and there was a letter in the mailbox from the city telling us about it. At that point, I hired a new realtor management company, and he immediately took care of all the licenses that were required. And that's the story. You know,
How many months was this not in compliance?
It was 959 days, so 30?
And notice was sent to the address in the property appraiser's records?
Yes, the address on the property appraiser's record was the address of the property. The application says she intended to live there, but then accepted a job in California, never changed the address with the county as far as the mailing address goes.
No.
Obviously, the tenant didn't inform her.
And I did change addresses with the public utilities, that everything else was going to New York. I'd never thought about sending a letter to the city to change the address. It just never occurred to me.
Well, the county property appraiser's record, actually, you're required to actually do that, but, let me,
How did,
so what are you asking me for?
I'm asking for a major reduction in the lien. There's no way in the world that we could afford that kind of fine.
You gotta ask me for something.
I'm asking for 10%.
So the city's asking for 30 and you're asking for 10. I tell you what, I'll do the same thing I did for the previous person. I'll split the difference. So I'll reduce it to 20% payable within 60 days, which would be $19,180. Okay?
Okay.
was that 9,180?
19,180, which is 20%. 60 days. It's a big number.
Have a good day.
Thank you for coming in, sir.
And that's it.
Seeing no further business before us, this meeting is hereby adjourned.